Mr. Chuck Michel, California civil rights attorney with Michel and Associates, is with us on the program right now. Chuck, how you doing, sir?
Good, Cam. How are you?
I am excellent. Glad you could be with us today. A lot of stuff to talk about in California. In fact, I got to say, before we get started, I saw a piece at NRAILA.org the other day that was just a listing, Chuck, of the court cases that the NRA is involved in California. And I would encourage California gunners. Every now and then I get an email from folks asking, what's the NRA doing in California? Go to NRAILA.org, read this, because this is just one part of what the NRA is doing. But, I mean, there are the list just seemed to be endless. I mean, well over a dozen cases, Chuck, it seems like you guys are working on in California.
As well as opposing regulatory efforts by the California Department of Justice Firearms Bureau and the Fish and Game to try and advance the animal rights extremist agendas, to try and the regulatory agencies to try and pass laws that make it more and more difficult to pass regulations, I should say, that make it more and more difficult to comply with the laws and make it harder and harder to get a gun. I mean, we're involved at every level. The NRA, not just our office, but the NRA employees in California, the NRA headquarters looking at California. It's one of the busiest states. Obviously, it's a battleground state among others, but it's one of the busiest states because headquarters and everybody out here recognizes that California is the breeding ground for bad ideas that then get exported across the rest of the country. So we're fighting in the courts, we're fighting in the executive agencies, we're fighting in the legislature, we're fighting in local cities. There's a whole list of all the dumb local gun control ordinances that we fought over the year and links to the letters that we sent opposing those things. So yeah, there's a smaller and smaller contingent as we inform and educate the California members about what the NRA is doing out here that still doesn't realize how much is really being done in California. And that list, I've sent that to all the folks in the building, and I'm glad you've got it, because when people do ask, you just forward them the link to that list, and they can see, that whatever information they're getting, that the NRA is not doing enough is not correct.
No, absolutely not. So let's talk about the Peruta case, which is probably one of the best-known cases that you're working on in California right now. Last week, as you told us, Chuck, Kamala Harris, the Attorney General, did decide to seek that en banc review by the Ninth Circuit Court of Appeals, asking the broader panel to reconsider the court's decision to not allow her to intervene. I know this gets kind of convoluted here, but in essence, she's asking a broader pool of judges, let me get involved in this case. I know I haven't been involved up until now, but I really do want to get involved right now.
Right. She wants to get involved so that she can ask that larger panel to overturn the three-judge panel ruling that finally recognized that the right to self-defense doesn't end at your doorstep, and that you have a right to bear, as in carry arms, as well as to keep arms in your home or wherever. She wants to overturn that. Now, she tried to get into the case to ask the 11-judge panel to overturn it. Her request was denied. So now she's asking the 11-judge panel to overturn the denial of her request to ask the 11-judge panel to intervene so she could ask the 11-judge panel to overturn the underlying decision. You're right, it's a bit procedurally exotic and very, very unusual. But we got an order today, so there's a scoop for you. We got an order today from the court instructing us to file an answer to her request for a review by the 11-judge panel of the denial of her request to intervene and get involved in the case. So we'll be filing that in right around Christmas time. It's due. So we're already working on that. Folks need to keep in mind, though, that even if we wind up with en banc review in this case, that's not necessarily such a bad thing, because even if we were able to keep the Attorney General out, and there are lots of good arguments to keep her out, because for years she has claimed that it's none of her business in every lawsuit that was litigated in this state, and she's fought to get out of those lawsuits. Ironically, now she's fighting to get into one. So it's basically she's talking out of both sides of her face when she tries to say that she should be allowed into this one. But if we don't have en banc review in this case, there are at least two other cases queued up where en banc has already been requested. So this intermediate step is going to be difficult to avoid, and the worst case scenario would probably be if the Peruta rationale is reviewed in the context of another case that won because they simply cited to the Peruta decision, but the court did not have the benefit of the entire court record from the trial court and the Court of Appeals to fall back on and consider when it was considering whether or not the Peruta decision was rightly decided by that 3-judge panel.
All right, now there's another case, Chuck, I wanted to ask you about while we have you here. A judge in Fresno deciding that, and this is an earlier decision, he rejected California's 10-day waiting period, at least for some gun owners, and now the judge has rejected a delay to ending this 10-day waiting period. What can you tell us about this case?
Well, this is an as-applied challenge as opposed to a facial challenge. This is not an NRA case, but it's a great victory because the judge has said that if you've already got a gun and you've got something that indicates that your background is clear, a certificate of eligibility or a CCW or something that requires you to have to be eligible to possess a firearm in the first place, then there's no reason, no constitutional justification for requiring you to wait 10 days to get another gun. So several classes of people will be able to get a gun without waiting for the 10 days to have a background check done. Or actually, it doesn't take that long to do the background check. They put the 10-day waiting period in there because years and years and years ago, before they had all the computer science, it might have taken that long. But it's sort of a relic and a huge inconvenience. And the trial court in Fresno, the federal judge struck that down, said you have to reconfigure, Attorney General, you need to reconfigure your computer system so that people can be approved without having to wait that 10 days. Kamala Harris, the Attorney General, went in and tried to get that order of the court postponed, said she needed more time and that she wanted to stay that order entirely while they appealed it and tried to get an appellate court to overturn the trial court. And the trial court judge said no. And this is really, she got a bit of a bench slapping, so to speak, from this court because he said, I'm not sure exactly where you put, how you prioritize things at the Attorney General's office, but fixing an unconstitutional law, you should be near the top of your list of priorities. So she had been saying, we don't have time, we have other more important things to do. And he said, no, this is about as important as it gets. They're infringing on people's rights, so fix the system so that people aren't subject to this waiting period unnecessarily.
All right, Chuck, listen, I appreciate you coming on the program, sir. Thank you for everything you're doing out there, and look forward to having you on again very soon.
We'll fight on, Cam. Thank you.
Yes, sir. Chuck Michel with Michel and Associates out in California.